The second day of the Nagaland Law Students Federation Silver Jubilee celebration opened with a panel discussion on systemization and documentation of Naga customary laws and practices and imperative during the first session with panelists including Nagaland DGP Rupin Sharma, convener of Concerned People of Nagaland Kauto Chishi, Assistant Professor of Department of Law, Nagaland University, Dr. Senti Kamla, and President of Koima Bar Association Advocate Kekhrengule Tenuo. The moderators were Advocate Joshua Sheki and Apila Sangta.
A custom which is against public morality is wrong. Honestly, a custom which is against a written code is wrong. It is illegal. Okay? I'll give you examples not from the Naga society but from my own society, which I have sort of given many times over in Nagaland, but I'll just say it again, maybe once, twice. Anytime I'll say it. In Hindus, we had the system of sati. Do you think sati was incorrect? Was correct or incorrect? It was not correct. A husband dies and the wife goes on the pyre and bursts himself. No, it was not correct. The Britishers changed it. Do you think the Britishers were wrong or they were interfering with our customs? No. They were interfering with something which was immoral, which was patently incorrect. We had child marriage. Do you think child marriage was good? It was not good. The Britishers brought in the child marriage, restraint act and all, limiting the age of marriage. Do you think that was wrong? No, I'm not saying just Naga society, in all societies, okay? Change has to come. Positive change has to come. Now we have to devise mechanisms for bringing in the change. Who will resist the change? The people who will benefit by the system remaining in status quo will never allow the change to take place. Okay? In the Naga society, pardon me, Kauto is a GB, but with respect to all GBs, the village council chairman and the GBs may not allow a change. Okay? You allow a change where you cannot impose a fine of more than 5,000 rupees or a theft or on a theft of more than 500 rupees or 1,000 rupees. Whose power is going? Your power is going. You will not allow that to happen. Okay? But that change has to take place. There is miscarriage of justice. This delivery of justice is wrong in certain cases. Practically for lawyers, if there is too much of over-dependence, I'm saying too much of over-dependence, I'm not saying over-dependence only, too much of over-dependence on customary law, your own profession is threatened by that. Okay, for lawyers, if everything was to be done by customary law, अपने का कुछ जवाना है, लगे ना लगे तो बुस्ती खान कुछ लगे वो फैसला वैसे. No, this is how systems evolve. You know, there are basic principles of governance, basic principles of justice and jurisprudence which evolve. I don't think there is any law in the country or anywhere in the world which says a Naga will do this, non-Naga will do this, Hindu will do this, Muslim will do this. Most laws are gender neutral, person neutral, any person. Most laws will use the word any person where a word human being is to be referred to. So there is a need for us to evolve.
So in this fourth amendment, they have renamed the village, Nagaland Village Council and Village and Area Council Act to the Nagaland Village and Tribal Council Act. And there, they have set in all the powers that the earlier area council had, they are trying to give it to the tribal bodies. Okay? And they are saying that the way previously where it was area council, now let it be tribal council. Then they said, there may be a tribal council for every recognized Naga tribe. And also one or more ethics tribal councils comprising of the federation or union of two or more tribal councils. Okay, keep that in mind. Then, section 24 says, the composition, tenure and method of constitution of tribal councils and ethics tribal councils, their powers, duties and functions shall be as per the traditions, customary practices and usages of the tribes concerned. Now, they have made a law and they have deleted the basis of the law. Because Naga customary law does not recognize any authority other than the village council. I've said this time and again. So how can you make a law which has no basis? They're using customary law as the basis, but there's no such customary law. So they have lied to us, and we're not aware. In fact, I was also not aware. This was in 2009. And the dangerous part is, you're talking about a grouping of 2 or 3 tribes. So, say take for example a Tenimia grouping. That means Rongmais will have a say in the affairs of Nagaland. Mauls will have a say in the affairs of Nagaland. Have you thought of that? And on what basis? Customary basis. Because no matter how much we may love each other, Nagas of Assam, Manipur, Arunachal, we're under different states. And Nagas of Myanmar, they're under a different country. So we must learn to operate within our areas before letting others come into our areas and interfere in our matters.
Judiciary has a duty to ensure that the rights of both the husband and wife are protected. How it can be protected. We may get married according to the religious practices or our customary practices, but how can we prove that we are married, in a board of law? So judiciary has a duty to ensure that the rights of both the husband and wife are protected. And the Supreme Court, in the case of Sima versus Ashwani Kumar 2006, observed a rule that all marriages must be registered without any exception for any religion. And it has also directed all the states to compulsorily register marriages solemnized in their jurisdiction. And based on the direction, states like the UP and even in the Northeast like Meghalaya, they have passed relevant status and made amendments to provide for compulsory marriage registration. But one thing is that most of the states have made registration necessary with a penalty for late registration. But one thing is that no state has made law that makes an unregistered marriage invalid or void. So non-registration of the marriage will not make it an invalid or void. But when it comes to practicality, there are certain impediments if our marriage are not registered. And in Nagaland, we very proudly say that we have Article 371A and under subclause 1. We have social and religious practices protected. Okay, so marriage or, however, in Nagaland also, we do not have a competent customary institution or an authority that can give the what we call the marriage registration. So that is something that I believe we need to explore further, like if we are governed by our own social and religious practices, that we get married under that and then our marriage is valid, but when it comes to produce that certificate, in to authorities, I know it is not, that cannot be a valid, and there is no, we cannot give evidence that it is the husband or the wife. And India, and even in India, this marriage certificates are not taken seriously. And we also think that only those people who need to take their spouses abroad or travel to foreign countries, they need a marriage certificate. But this marriage certificate has a great deal of importance for the society and the people. The process of registration not only gives legal recognition to the relationship, but it also provides certain securities to both the wife and the husband. In case of a divorce, a legally registered marriage makes the process of separation smoother. And if either the husband or the wife dies, a legally registered marriage makes life simpler for the surviving spouse. If one has to claim life insurance upon the death of a partner, the living spouse has to produce a marriage certificate. And it is said that even the educated women are not aware of the importance of having a marriage certificate. And one difficulties they will face is that if they decide in future to part ways with their spouses and claim their alimony. For example, in every marital dispute, also the court asks for evidence for marriage, as judge doesn't know whether the couple fighting for divorce are married to each other or not. Because we have seen the example of Mick Jagger and Jerry Hall. They were assuming that they have been married for 21 years, and after 4 kids, Jerry Hall filed for divorce, and then later on he realized that they were never being married. So registering the marriage is very important, and also the rule of the customary institutions also in future has a IPD part to play on that.
When it comes to the property, now we have the 2 categories of properties in a family. The first one is ancestral property, and the other one is self-acquired property. Ancestral property, in respect of ancestral property, that will pass on through from father to son. But when it comes to the self-acquired property, will can be made by father, or the alienations of that property depends on the father or a person who acquired it. We all know our state is a little peculiar, but when it comes to property, now the landed property, initially entire Nagaland, this land that belonged to people, and more or less we can say that these are ancestral property. But once it's sold off, that the ancestral tag that is removed from it. Once it's sold off to another individual or group or to the government, then that ancestral property, that tag removed. Ancestral property that we know that when it comes to the inheritance, it varies from village to other village. But when it comes to the ancestral property now, the inheritance, the Angamis and the owls difference in respect of a person who to occupy the parent house. In Angamis, the youngest son will normally take over the parent house. Whereas in owl's custom, the eldest one, and it has got its own reason. not just to inherit the assets, but also to inherit the liabilities that your father or your parents who has handed over or who has left behind. This is important. We talk about, the benefit. But the liabilities, that also important. Why the younger son has to inherit the parent house? To look after the aged or the aged parents. He has to look after the family affairs. This is how the inheritance that takes place. I remember that one of my uncle told me that in ours, when the husband died, then they give normally that the dow of the husband will give it to the wife, so that wife will always have have in mind that still husband or the power of her husband still remains with her. These are some properties that we all know that, see, self-acquired property, once the self-acquired property, then the custom, the family custom, that even in custom we can find like this. We have the local custom, we have family custom, then we have come to the tribe customs also. Local, tribes or caste, and coming to the family. Once it is solved and a person has an acquired property, self-acquired property, then the family custom will come into play. Once the father died, the sons cannot just come and grab it over. So long the mother and the daughters, unmarried daughters are there, they can enjoy the property. So long they remain unmarried and in the family, they will enjoy the property. During their lifetime, nobody can just take it away, or the sons cannot just take it